Yo ho ho. It's me, Fax5. I'm doing this format again. You might be asking, Fax, what are you reading? And I'm gonna tell you that you should probably look at the title of the video because there's a good chance I wrote it in there. But for more context and more details, I'll just tell you right now. I'm currently looking at the 3 default orders that one Alex Emmerich Jones received from the District Court of Travis County, Texas, on September 27th, 2021. You might be thinking, well, wait a second, this is from like a year ago, who cares? And I'm telling you, I'm just reciting this because, well, it's been in the news recently about Alex Jones's infamous billion-dollar effing civil verdict. Oh, God, what a yutz. But, oh, excuse me. But I've been seeing a lot of people just buying into his own, self-aggrandizing propaganda about how he's been railroaded and whatnot. And I'm like, you know what? Let's cut past the propaganda and look at the actual legal documents straight from the horse's mouth. All right? So I've got, what do I got here? I got three PDFs with the info on them. Pretty short. But they go into a lot of detail. You can find these PDFs in the description. You can follow along if you want. I'll probably be putting the the words on the screen. Okay. Now these all say September 27th, 2021 at 3:30 p.m. So as for the order, I'm going to organize them based on the first date that appears in the background section. Likewise, I'm also going to be looking at the numbers in the the numbers in the court cases. The first one is Leonard Posner and Veronique de la Rosa, plaintiffs, versus Alex E. Jones, Infowars LLC, and Free Speech Systems LLC, defendants. Order on plaintiffs' motion to compel and motion for sanctions. On this day, the court considered plaintiffs' motion to compel and motion for sanctions. The court finds that the motions should be granted. Background. On May 29, 2018, plaintiffs served written discovery on defendant Free Speech Systems LLC. 28 days after service of the requests, defendants filed a TCPA motion, which was subsequently denied and appealed. Okay, a TCPA motion. Let me just double check what that is. Okay, from some Texas legal blog. Okay, so it basically looks like the TCPA is the Texas Citizens Participation Act, which it's an anti-SLAPP suit law, which basically says that if you think a lawsuit is bullshit, you can, try to. Excuse me. Sorry, I thought I was about to sneeze. If you think a law is bullshit, or not law, sorry, a lawsuit is just crap, it's just an attempt to try to shut you up, then you can get it, thrown away as frivolous under the TCPA. Looks like AJ and company tried to do that, and it was denied. All right. 1 month after remand on July 2nd, 2021, plaintiffs wrote to defendants inquiring about the overdue responses. Plaintiffs offered an additional 14 days for defendants to provide responses, in which case plaintiffs agreed to waive any complaint about their timeliness. That same day, defendants' counsel requested that the plaintiffs' counsel provide a copy of the Posner discovery requests. More than 3 weeks later, on July 27th, 2021, with no responses provided, plaintiffs brought the instant motion. Defendants have never answered the discovery requests. Oh boy. Yep, he was very clearly railroaded. You can tell he was so railroaded that he never answered the discovery requests. Yep, he'll say, oh, I gave them everything, but the legal documents say otherwise. That's some good apple cider. The court fined defendants unreasonably and vexatiously vexatiously, that's a fun word, failed to comply with their discovery duties. The court finds that defendants' failure to comply with discovery in this case is greatly aggravated by defendants' consistent pattern of discovery abuse throughout the other similar cases pending before this court. Prior to this latest discovery failure, defendants repeatedly violated this court's discovery orders in Lewis v. Jones et al., Heslin v. Jones et al., and Heslin v. Jones et al. Alright, I guess there's another one with the same name. All of which are related cases involving defendants' publication about the Sandy Hook Elementary School shooting. Defendants also failed to timely answer discovery in Fontaine v. Infowars LLC et al., a similar defamation lawsuit involving defendants' publication about the Stoneman Douglas High School shooting. The court also notes that defendants have repeatedly violated discovery orders in Lafferty v. Jones, a similar defamation suit brought by a different set of Sandy Hook parents in the Superior Court of Connecticut. The court finds that defendants' discovery conduct in this case is the result of flagrant bad faith and callous disregard for the responsibilities of discovery under the rules. It is clear to the court that discovery misconduct is properly attributable to the client and not the attorney, especially since defendants have been represented by 7 attorneys over the course of this suit. Okay, 7 attorneys. Man, like imagine being just such a terrible client that like what? Did 6 of them quit on you? Did you fire them? What? Excuse me. Like what happened? What the heck happened that required you to get 7 different attorneys throughout this? Regardless of the attorney, defendants' discovery abuse remain consistent. Oof, you know? I'll be honest, it doesn't prove anything in a criminal court, but I will say it is a bit sketchy if you have 7 different lawyers and, well, your legal team is still acting in the same sketchy, abusive, non-compliant way. Well, it's not really, I'm not going to say it's their fault. For these reasons, it is accordingly ordered, orders in all caps, that sanctions be asserted or be assessed defendants, including the following remedies under Rule 215. Hang on, let me check what Rule 215 is real fast. Rule 215, Texas. Okay, so according to case text, it looks like, 215 is motion for sanctions or order compelling discovery. Okay, yeah. Yeah, in a lawsuit, discovery is, the part that's kind of before the actual court stuff happens, where both sides will will legally be required to exchange various informations to try to, make their point. Okay, let's see. A judgment by default against the defendants, as this court has considered less sanctions and determined they would be inadequate to cure the violation in light of the history of defendants' conduct in this court. In reaching its decision, this court has considered lesser remedies before imposing sanctions that preclude defendants' ability to present the merits of their liability defense. However, the court has more than a sufficient record to conclude that an escalating series of judicial admonishments, monetary penalties, and non-dispositive sanctions... Non-dispositive? Wait, hang on, let me double check. Non-dispositive. Let's see, okay, so... so dispositive is related to or determining the outcome of a case or decision. Alright. Non-dispositive. Strange word. Technically, it's just 2 words with a hyphen between them. So non-dispositive sanctions have all been ineffective at deterring the abuse. This court rejects lesser sanctions because they have proven ineffective when previously ordered. They would also benefit defendant and increase the costs to plaintiffs, and they would not adequately serve to correct the defendant's persistent discovery abuses. Furthermore, in considering whether lesser remedies would be effective, this court has also considered defendants' general bad faith approach to litigation, Mr. Jones's public threats, and Mr. Jones's professed beliefs that these proceedings are, quote-unquote, show trials. It is further ordered that defendants shall pay reasonable attorney's fees in connection with plaintiff's motion. Plaintiffs shall submit evidence regarding the reasonable value of the time expended by their attorneys related to their motion. Dated September 27th, 2021, the Honorable Maya Guerra Gamble. Alrighty. Next one. Scarlett Lewis, plaintiff, versus Alex E. Jones, Infowars, LLC. Sometimes when I see LLC, I don't know why, I just feel like there should be an echo in it, LLC. And Free Speech Systems, LLC, defendants. Order on plaintiff's motion for contempt. On this day, the court considered plaintiff's motion for contempt. The court finds that the motion should be granted. On July 25, 2019, this court ordered defendants to respond to court-approved discovery requests by February 25, 2019, and appear for depositions by March 25, 2019. Defendants refused to provide any documents, citing the reporter's privilege. In an order on March 8, 2019, this court ordered defendants to immediately produce all responsive documents. Therefore, defendants failed to produce any documents or prepare their corporate representative for deposition. After defendants failed to comply with the discovery order, plaintiff brought a motion for sanctions. A few days prior to the sanctions hearing on April 3, 2019, defendants provided a set of documents. However, defendants' counsel admitted at the hearing that the documents were incomplete and not sufficient. I had it all, thought I had it all together, but I was led astray the day you looked away. You were the clock that was ticking in my heart, changed my state of mind, love so hard to find. Now, anyone who's ever listened to any Alex Jones knows that, well, it's a recurring theme of his to assert that things are, in no particular order, mainstream news, admitted, and or in the white papers. Whatever the heck the white papers are. Well, I got right in front of me literal white paper. I mean, it's on my screen, but it is a white piece of paper. It would be a white piece of paper if I was holding it. With a confession that the documents that Alex Jones and InfoWars LLC and Free Speech Systems LLC gave out were, quote, incomplete and not sufficient. So, to any of you propagandists who are utterly convinced that, that Alex Jones was railroaded, we have it here, admitted, in the white papers, in the mainstream news. Well, okay, I'll be honest, I don't count as mainstream, I guess. I mean, I wanted to try to combine all three, but fine, I got two. We got it here, in the white papers, an admission that the documents they provided were incomplete and not sufficient. It's right here. In fact, you know what, maybe I should just take a screenshot, put it on the screen or something. Like, normally what I do is I'll either copy-paste the text and put it in the video, or I'll just type it up myself, and because I have had to type some things myself, it was actually kind of fun, I guess, to practice my typing, but whatever. But just to show you, right in front of you, in black and white, in the legal white papers, a confession that the documents provided were incomplete and not sufficient. Defendants' counsel agreed to pay $8,100 in attorney's fees and abandoned defendants' TCPA arguments except for a sole legal issue to avoid being sanctioned at that time. Defendants then unsuccessfully appealed the court's denial on the TCPA motion. Following remand on June 4th, 2021, defendants took no action to comply with the January 25th discovery order or any of the court's other discovery orders for over a month. Plaintiff then filed her motion for contempt under Rule 215 on July 6, 2021. Even after that motion was filed, defendants continued to withhold discovery through July and August. On August 26, 2021, a few days before the hearing on this matter, defendants provided some additional documents to Ms. Lewis, but it is clear these documents do not satisfy defendants' outstanding obligations. In addition, defendants did not provide any supplemental discovery responses, nor did defendants make efforts for a corporate representative deposition to cure their non-appearance, nor have the defendants fully and fairly responded to the discovery requests at issue. So to anyone who's honestly believing Alex Jones' claptrap that he was being railroaded, we have it right here in the white papers, a confession of their own misconduct as well as the charges laid out against them. Predictably, Alex Jones and his allies refused to acknowledge this. Why do they refuse to acknowledge this? Of course I know why they refuse to acknowledge this. It would ruin their narrative. Findings? This court finds that defendants have intentionally disobeyed the court's order. The court also finds that defendants' failure to comply with the discovery order in this case is greatly aggravated by defendants' consistent pattern of discovery abuse throughout the other similar cases pending before this court. Defendants violated this court's discovery orders in Helson v. Jones et al. And another Helson v. Jones et al., both of which are related cases involving defendants' publication about the Sandy Hook Elementary School shooting. Defendants also failed to timely answer discovery in Posner v. Jones et al., another Sandy Hook lawsuit, as well as Fontaine versus Infowars LLC et al., a similar lawsuit involving defendants' publication about the Stoneman Douglas High School shooting. Excuse me. Well, let me just look at this. Yeah, it looks like this part is basically the same. Let's see. It asks for a judgment by default against the defendants, as this court has considered lesser sanctions. Yeah, I mean, it is basically the same thing. And the final one. Neil Heslin, plaintiff, versus Alex E. Jones, Infowars, LLC, and Free Speech Systems, LLC, and Owen Schroyer, defendants. On this day, the court considered Neil Heslin's motion for default judgment. The court finds the motion should be granted. Background. On October 18th, 2019, this court ordered expedited discovery in Mr. Heslin's IIED claim. IIED. Hang on, let me double check what IIED means. IIED. Oh, intentional infliction of emotional distress. Okay, yeah. Including written discovery and depositions. Defendants failed to comply with the order in numerous respects. On December 20th, 2019, the court assessed sanctions and held the defendants in contempt for intentionally disobeying the order. Oh, God. Hang on, let me get my cider. Oh, some good apple cider. He's got a... Man, now you can hear me blow my nose. Well, yeah, probably got a little cough going on, or maybe a little fever or something. Well, I checked my temperature, it was alright. I also did a COVID test, and that turned up negative. But hey, I want to read this just in case I can't talk tomorrow. On December 20th, 2019, the court assessed sanctions and held the defendants in contempt for intentionally disobeying the order. At that time, the court took under advisement all additional remedies based on representations by defendants that discovery would be properly supplemented during the appellate stay. As the court stated in its prior order, the amount of supplemental discovery would be a factor when revisiting sanctions upon remand. Despite their promises, defendants failed to supply any discovery following the 2019 hearing, and prior to remand, defendants also failed to supplement any discovery for nearly 3 months following remand in June of 2021. On August 26 of 2021, a few days before the hearing on this matter, defendants provided some additional documents to Mr. Heslin, but it is clear these documents do not satisfy defendants' outstanding obligations. In addition, defendants did not provide any supplemental discovery responses, nor did defendants make efforts for a corporate representative deposition to cure their non-appearance, nor have the defendants fully and fairly responded to the discovery requests at issue. So we got it here. We got it in the white papers, all right? Right here in the white papers. The facts that Alex Jones doesn't like to talk about, all right? The way that he and his legal buddies, and by legal buddies, I mean the fact that he had 7 different lawyers throughout this. They abused the discovery process, and the fact that his behavior was consistent throughout the discovery process, regardless of which of these 7 lawyers. 7 lawyers. 7 lawyers he had employed at the time. Additionally, we have a literal confession from Alex Jones's legal team that the documents they provided were not satisfactory. We have multiple instances of abuse of the legal process, and if you think you can just ignore this bullcrap, then I got a Brooklyn Bridge to sell you, buddy. Well, this should be about the end of it. Like and subscribe if you want. Or don't. I'm not your boss. I'm just Fax 5'em. And right now, I'm signing off.